Hey, what's up guys, this is Averroes here and welcome. In this video, we are going to be talking about international law, a subject that you'll be learning in your respective universities. International law is a very interesting subject, even if you might be a future lawyer and somehow international law may not be relevant to you. International law does relate to us in a lot of ways. Firstly, it can give an impression that you are a very knowledgeable lawyer or law student. Starting at number one, what is international law that you'll be learning? International law is a collection of treaties, conventions, and statutes. Customary international law is basically your judicial precedent. It is the practice or some sort of case laws developed throughout the whole age. For example, the law of torture, even though countries do not have a convention or do not have a written law about it, but countries generally around the world accept the customary international law or the norms or customs that torture is a bad thing, it is illegal. For international law, you have the United Nations, which is an international body. You'll be learning about the history of the UN, starting from the failure of the League of Nations right after World War I and the formation of the United Nations with its organs and its agencies and its bodies such as the UNSC, the UNGA, the ECOSOC, ICJ, as well as the International Criminal Court. Coming up next is international and municipal courts, whereby Malaysia and international law, how do we have some sort of harmony, perhaps maybe a nexus or a linkage between the two? For instances, we have international law, which allows for these sort of LGBT rights, laws or rights which is in contrary or opposed to Islamic law. Can international law actually empower over local Malaysian laws? Well, the answer is, it is up to you to argue. Personally, for me, I don't think that international law can have precedence over municipal or local laws because the federal constitution is the supreme law of the land and we already have our own laws to govern the local people. Unless we adopt the international laws through ratification, through being a signatory, only then we consent and we have to follow international law. Moving forward, like I mentioned before, in relations to the ratification and signatory, you have the Vienna Convention on the Law of Treaties, VCLT, where we have to study as to how we can ratify or become a signatory to an international treaty. It doesn't necessarily have to be through a signature, but it can be through the accede, like words such as accepting, acceding. It can be through the oral acceptance by the governmental representation. There are several ways of ratification. Also, the VCLT also specifies on reservation. Reservation means that when you adopt an international treaty, you do not want to adopt everything in the international treaty, so you make a reservation. For example, maybe the international treaty says that your country has to pay around $10 billion a year. So as a country, as yourself, you do not have the ability to pay that much. That is why you want to make a reservation. You do not want to pay $10 billion per year. Moving forward, we have the concept of statehood. Statehood means that can your country exist? A country can exist in two ways, such as the declaratory and the constitutive theory. The constitutive theory is when you fulfill the four requirements or the four elements, is that you have a territory, you have a permanent population, you have a government, and that you are able to enter into legal relations with other nations. So for example, is Palestine a country? Is Palestine a state? Palestine needs to comply with the four requirements. Palestine does have the land, they do have territory, even though it is disputed with Israel. They do have a permanent population, they have Palestinians in their territory. They do somehow have a government. They have Hamas and Fatah, the two ruling governments in the West Bank and the Gaza Strip. And then lastly, they can enter into relations with other countries because Palestine, they have embassies in Malaysia, they have embassies in Western countries, including the Vatican City and even Sweden. However, we have the declaratory school, which adds another requirement that in order to become a country, other countries must recognize you. So the problem right now here is that the declaratory school is politically motivated. The United States and that the Western countries, they do not recognize Palestine. So when they do not recognize Palestine, it's really hard for Palestine to become a functional country, to be an actual country, because the United States of America and their Western allies are among the richest countries in the world. So if these countries do not recognize Palestine, that is why Palestine is still in a state of conflict. There's so many bloodshed for them to survive and become an actual functional country. Moving forward, we have state responsibility. State responsibility means that when there is country A and B, So when country B commits a wrongdoing to country A, how do we say that country B is responsible for their actions? So for example, country B has their people, and citizens B commits a crime against the people in country A or the citizens of A. In order for us to determine that citizen P is responsible, we have to show that citizen B is connected with country B. So for example, citizen B, maybe country B orders them to, destroy or disrupt country A. Another example is that I can give you is that about the Iranian hostage incident. In that case is that people in Iran attacked the US embassy, and the US wanted to say that Iran must be responsible for the Iranian people that attacked their embassy. The Iranians that attacked the embassy was under the implied instruction by the Ayatollah to attack the embassy. In addition, we have diplomatic protection. Even if country A harms you as a citizen of country B, how do we as the citizen of country B wants country B, our country, to take action against country A? There are 3 requirements that we want to take action against country A, and that is we must prove that we are a national or a citizen of country B. We can prove that we are a citizen perhaps through documents, or that we have lived in country B for a very long time and we have our family there. Secondly, if we want to take action against country A, we need to exhaust local remedies. We need to say that when country A commits a action or a wrongful act against us, we need to appeal to their courts. So we need to sue country A in their courts, and we have to exhaust all remedies. We have to appeal all the way to country's apex court. And the last requirement is that country A must commit some sort of wrongful act which is contrary to international law. So maybe perhaps under international humanitarian law or other human rights law, country A might have deprived us of the rights to have a good job or employment, or they have taken away our land or our house. We are going to be proceeding with jurisdiction. Jurisdiction means is that when someone commits a wrongful crime, which court in the world has jurisdiction to try over them? Which court do they have to go to? Maybe, for example, if they commit a robbery, or they committed murder, or they commit some sort of other crime, which court does this people have to go? There are several ways for us to determine which court does this people go to. For example, in territoriality, we have subjective and objective territoriality. For subjective territoriality, someone commits a crime in country A, but then they go to country B. When they go to country B also has the jurisdiction to bring them to their court, even though that person commits a crime in country A, because that person completes the crime in country B. Objective territoriality is the complete opposite. Someone commits a crime in country B, but then they go to country A. So country A has the jurisdiction over the person because they complete the crime in country A. So it's just a matter of switching sides of the coin. Next, we have nationality jurisdiction. We have active and passive jurisdiction. Active nationality is that our country has jurisdiction over us if we commit a crime in another country. For passive nationality, it is when that a citizen of country A goes to country B, but the people in country B commits a crime against our citizen. The courts in country A can prosecute or take action against the citizen of B that committed a crime against our own people. We have protective jurisdiction, which is a type of jurisdiction which applies to acts against the peace and security of our country. So let's say that in country A and there's country B, but then there's a person in country B that's threatening to bomb country A or wants to do this sort of terrorist act against country A. So therefore, we have protective jurisdiction because there is someone from a different country that wants to destroy our country. And the last form of jurisdiction is universal jurisdiction. This universal jurisdiction applies where our courts can take action against everyone in the world, regardless of their territory and where they belong, unless and until that type of offense or law is a universal type, such as genocide, such as terrorism, such as acts against humanity. To summarize today's video, I want to touch upon the last topic, and that is diplomatic immunity. Diplomatic immunity means that when a country commits a crime or something else or does a wrongdoing, a country has an immunity. It means that you cannot take a country into another country's court, but there are certain exceptions. And some of the exceptions is that, again, as I mentioned before, if that country commits a genocide or a human rights abuse against their own people, only then maybe another country may take action against that country in their own court. Or that country B is in a a commercial transaction. So when a country is in a commercial transaction or trade, they cannot use immunity. In this topic, you will also be learning about diplomatic immunity concerning the agents and the officers of another country. This will be the ambassadors, the diplomats of a country, and you'll be looking into the Vienna Conventions on diplomatic immunity or diplomatic protection, and then the Vienna Convention on consular relations. So let's say that you are a diplomat of country B and you go to country A. So you have so many privileges and protections when you go and enter into country A. For example, when you go to country A cannot check your luggage because you are protected and that it is a diplomatic bag, and that your family also have the same privileges and rights as you are as a diplomat or a ambassador. You, as a citizen of country B, working as a diplomat, you don't have to pay taxes for country A. As you, as a representative of country B, country A cannot check your documents. They cannot check any secret information that you have related to country B. What's more interesting is that you, as a diplomat, even though you break the country A's traffic laws, you are not responsible because you have protection, civil and criminal protection. Even though you might commit murder, you won't be responsible because you have the immunity. And that is the, perks of having diplomatic protection. But your diplomatic protection can be revoked through persona non grata. So if the country wants to exile you or wants to kick you out of their country, you're given 24 hours. And if you exceed 24 hours, your diplomatic protection ends. Or that if country B revokes your diplomatic protection or immunity, therefore you do not have the same privileges that you have before. So that is all that we have here in international law. Thank you guys so much for tuning in. I hope that this video is very helpful. If you want more help, leave a comment down below in this video and can check out my notes that I provided in the description box below. And until then, thank you guys so much for watching and see you next time. Thank you.